All right, this is your motion to vacate, please, motion to vacate and dismiss. Okay, thank you. I'm going to go ahead and grant it and we'll set it up.
Thank you, Your Honor.
Thank you so much. Mr. Saltier, you want to make the bills?
It is counsel for defendant hasn't made it yet, but we don't have a problem with a reasonable extension.
Let me go ahead and give him 10 days. Tell me the extension on that. Okay. And I have Wilmington Savings Black.
Yes, good morning, Your Honor. I'm still waiting for...
Okay. So we're waiting on the conglomerates, we're waiting on Black, and we're waiting on...
Everybody was late.
Okay, what about Gaggle? 15 minutes Gaggle?
That's okay.
The pro se defendants, Your Honor,
Yeah, we all were.
This one is
Everybody was.
kind of discovery as to defendants, they're both, and I read the motion. I'm going to go ahead and grant it at this point in time. How much time should I give you?
I'm pretty sure 20 days, but that's
All right, anybody else here for argument? All right, otherwise we're waiting for the last two from Roberts.
If Roberts is
On the front.
It doesn't matter. Just
All of them?
yeah. Just
Okay.
All right, good morning, and we're going to have a court order. This is Ms. Roberts versus Sarcella. Could counsel please give your appearances for the record?
Brian Yarnell,
And David Franklin on behalf of the defendants.
Good morning, it's very nice to see both of you here this morning. We are here on the defendant's notice of hearing and the defendant's add-on as well. And I read both. You may proceed when you're ready, counsel.
Yes, Your Honor. I'm going to start with the short of it. Both of these are our motions. The first is a simple motion for fees. Our several corporations were sued for fraudulent transfer and unjust enrichment claims. They all proposed separately proposals of $1,000 each. They've now been dropped, and the rule provides that the court shall enter award of attorney's fees should the
You
plaintiff...
just want entitlement right now?
Just
not
entitlement.
Okay, all right. Any objection?
Yeah.
Okay, that's granted. All right, let's do the other motion.
The other issue, Your Honor, and it's a bit more complex, and it got a little bit more complex because we did get some documents, not from the plaintiff, but from another party recently.
Okay.
Again, the short of it is that 2.5 years after the beginning of this lawsuit, well, for some context, the plaintiff is alleging that he was part of this transaction that culminated in February of 2012.
Okay.
That was before Mr. McRoberts had our discovery. From the discovery, he now knows that before all of this happened, the property was already bought 4 months before he alleges that all of this went down.
Okay.
He also alleges that all of these communications and negotiations started somewhere in the summer of 2011.
Okay.
Through discovery, he now knows that there were several emails, hundreds of emails regarding this transaction that really started in April and earlier in 2011.
Okay.
So Mr. McRoberts at his deposition changes his theory and now testifies that there was really a meeting in January of 2011 before all of these emails, so that establishes that he was there in the beginning, according to him. And he testified that he has the documents to prove it, which we haven't seen. Several emails with his financier, because he's alleging that he was going to be loaned the money by a man by the name of Sam Jennings to be a principal of this transaction, in addition to his claims that he's a broker. At his deposition, he says that he has 40 to 50 emails involving Mr. Jennings. He has comp reports, property comparison reports, recordings regarding dictations that he made regarding the case, and text messages. We rescheduled a continuation of his deposition. We had to cancel that because we haven't gotten the email.
What do you need at this time, counsel? Let's just cut to the chase.
Well, we need all these documents that he identified.
Yeah, what's the position?
My client is trying to find additional documents that he didn't have at the beginning.
Okay, how much time does he need?
I think he could probably do it in 30 days, and the reason I say it that way is I'm withdrawn.
Okay, all right, so motion to compel is granted, 30 days to respond. Counsel, go ahead and file your motion to withdraw.
I've already filed.
Okay, that's fine. Motion to compel is granted. All right, thank you.
Thank you.
All right.
Well, one more thing, Your Honor.
Yeah.
And we also want a date certain for the continuation of the deposition.
Yeah, let's go ahead and put that in the order. Let's do the deposition within 30 days. All right, thank you. Have a great day then. Clinton versus Mosley. Plaintiff's motion for final judgment. All right, come on up. This is Clinton versus Mosey, plaintiff's motion for final judgment. And I read your motion, everything looked to be in order. Would you like to add anything to the motion?
Nothing I wanted to add.
Okay, you can hand the judgment up, I'll be happy to sign it.
Okay,
Thank you so much, have a great day. Puglizio versus DiMarzio.
Your Honor, I'm here.
Telephonic?
No, I was going to, but I made it. There was a bad accident on Okeechobee and
No problem.
it
This
took
is a
me an hour
motion
to
to strike
get
the
here.
expert and objections to defendant's amended exhibit list.
Yes, Your Honor.
And I read your motion, Mr. Cohen, you may proceed.
I pretty much briefed it out in the motion. The case law is pretty straightforward. The rules are there for a reason. We got it 2 days before counsel.
Yeah, we're coming up on the trial, so what's the status at this time?
Which one are we talking about?
This is, well, which expert is this one?
This is Joseph Giovanoso. The counsel listed him as an expert.
Giovanosa.
No.
This is an individual that was disclosed in discovery
Okay.
way back in the early part of
Has
the
he been
year.
deposed?
No.
Has he been, oh, he needs to be made available for deposition?
I didn't even know this was a person who was.
He was disclosed.
What kind of expert is he?
He's just a treating physician, is what he is.
You're going to use a treating physician as an expert on
You
what?
know, Judge, this particular case, there's not significant injuries to my client. There's scars, marks and scars on his arm,
Okay.
and he had a bocce ball kicked in his ankle. There's not,
So is
there
it
was no
consolidation?
fractures.
It doesn't sound like it's much then, so.
It's not much, quite honestly. Judge.
Okay, so
It's
then,
not-
do you need an expert? What are you going to do?
Well, you know, if I have to have somebody, it all depends
You're
on.
suing because he got hit by a bocce
It's a
ball?
counterclaim, is what it
Okay,
is.
the counterclaim is
It's
he
a
got hit by a bocce ball. Okay.
Yeah, this is an alleged attack of
I
some
know, I read
sort.
the other part, yeah.
So it's not, and it's, the defense is that, you know, my client was not the aggressor,
Okay.
so the individual was the
Did he
aggressor.
get hurt by the bocce ball?
My client?
Yeah.
He had some, yeah, he had a swelled ankle and he's got photos
He's
of it.
suing for a swollen ankle? Does he get
Counterclaim, and
You
for.
sure you want this in front of a jury? He got hit by a ball.
Well, we don't have a choice, Judge, we're the defendant.
But that doesn't mean, okay, all right, that's fine. You
We're
can sue for
defending,
whatever
right?
you want to, but I'm saying if they prevail, they're gonna get fees and cost. And it might, I don't know if that's the best strategy. I've tried a lot of cases, but that's your call. So,
I understand.
okay, that's fine. So
I
you're gonna
mean-
use this expert as a, the expert needs to be available for deposition and you need to comply. So when is he gonna be available for deposition?
He lives in New York, Your Honor.
Yeah,
I just have to give him a call.
he needs to come in. Because he's testifying, you're having a affirmative claim, so he needs to be available for deposition within the next 3 days.
You want him available here in Florida?
He's the expert, yes, sir. Okay? That's why I'm not sure you want to bring this claim, but it's up to you, counsel.
Well,
So-
then I'll amend it just to a regular witness then.
He still needs to be here. You're bringing a affirmative relief. The witnesses have to be deposed in Florida. He has to fly down to Florida because your client got hit by a bocce ball. Okay? All right, thank you. Wilmington, motion's granted.
Thank you.
Wilmington Trust versus Celestin, do we have a team? Oh, still waiting?
I'm still waiting on defense
Okay.
counsel on that.
And then what about Black? Do we have a team yet?
Yeah, I've emailed, called, and texted. I haven't heard from
Okay,
them.
well, we wait a few more minutes. If we got a team, let me know. Not a problem. You guys are my last two. Thank you.
Court's back in session.
You guys ready? Okay. Oh, do you have a question?
Judge, I need a clarification on this order. If my client, the expert witness, makes himself available in Florida for a deposition,
Yes.
then the order's
Yeah,
denied.
motion, yeah, that's fine. Motion's denied then. As long as it's until available for deposition, that's all we need. Okay, for the next 3 days. All right, thank you guys so much. Do we have some more teams ready? Do we have a team ready on Wilmington versus Black?
Yes, Your Honor.
Okay, come on up.
I'm on that, Your
Okay. All right, good morning. This is Wilmington versus Black. Could counsel please state their appearances for the record?
Nathaniel Callahan for plaintiff Williamson Trust. James Ackerton on behalf of the Blacks.
All right, is your motion to strike the trial order? Why are we moving to strike the trial order?
Well, at this point, everything is moved. Last night, I received a suggestion of bankruptcy.
Okay.
So
That's
now the
good.
case is stayed.
Okay, case is stayed. All right, that's fine. Then you
That
can-
approach?
I don't need it then, that's fine.
Very good.
All right, thank you guys. Have a great day.
Thank you.
All right, Wilmington Savings Celis, we're still
I'm
waiting?
going to give him 5 more minutes.
No problem. All right. Any other teams coming up?
I'm on that.
Your Honor, would you like an order staying in the case?
No, we don't need it. That's not a problem. Don't thank you, so. Do you guys have another question?
Yes.
Sure.
Is it denied?
Motion is granted unless the witness is available for deposition within the next 3 days. All right, let's proceed. Counsel, good morning. What case you guys here on?
Good morning. Your Honor, Rico Lively on behalf of the defendant, Portofino Associates.
Okay.
Thank you. Caroline Zakic on behalf of the plaintiff Ada Perez.
Okay, let's go ahead and proceed. I read your motion, counsel.
Okay, there's two motions, but they're both very similar and they both address more
Counsel,
or
are
less
you guys
the
waiting for an
same.
order? Yes. You're going to get the order by email. You need it's a motion continuing, it's denied. Oh, okay. I submitted an order. Okay, thank you. You'll get it in like 2 minutes by email. Okay, that's fine. Okay, I'm so sorry.
That's okay. They both address sort of the same thing. It's just discovery stuff. One is a motion to compel plaintiff's privilege law, but we just worked that out, so
Oh, good.
that's been
Excellent.
resolved. The second one is the motion to compel, or motion to overrule objections and compel answers to our request for production. We worked out some of that, so we've got it narrowed down to just one issue.
Sure, let's do that last issue. Perfect.
It's request number 20 and our request for production, and it just reads copies of all messages, tangible and digital, including emails, text messages, social media messages sent and received between plaintiff and any individual plaintiff claims who was visiting a defendant's apartment complex known as Portofino Associates from the date of the accident, June 2nd, 2016. And then, I apologize, this was poorly written by me, but it should be June 2nd, 2016 to the present.
Okay. What's the basis of the objection?
Your Honor, we object as to overly broad. It's not reasonably calculated to lead to the
Can we narrow
discovery.
the time frame? Is that possible?
We object to the time frame and I'm relying on the Root versus Balfour case. It was out of the second DCA. It's a 2014 case that basically said a plaintiff doesn't
No,
have
I'm familiar with it. I wrote the social media order that went kind of viral, so I understand it, but the 4th DCA says it is discoverable. So I'm going to go ahead and grant that, and we can narrow the time frame if you need to. What's the basis of the time frame?
The time frame right now, it's both before when the fall occurred and days after.
They're entitled to that, so yeah. So let's do maybe 2 or 3 months before and then afterward as well. So I'm going to grant your motion then. We can narrow the time frame maybe for a 5-month period before and after the accident.
And Your Honor, that would pertain to both text messages and Facebook messages, correct?
Absolutely, both.
Okay.
All right, how much time to produce?
I would ask for 15 days, Your Honor. You have to.
Is that okay, 15 days?
No objection to 15 days, Your Honor. Thank you.
Thank you so much. All right, let me know when we're ready on Wilmington versus Sasser.
Your Honor, I think we've waited.
That's the one, yeah, we have.
Half
Let's
hour.
proceed, yeah. I don't know anyone's coming. So let's go ahead and proceed, and this is your motion. You can proceed when you're ready.
Thank you, Your Honor. This is a pretty garden variety foreclosure writ of possession. The only potential hiccup is that there's a pending appeal, but no bond was posted.
Yeah, you're
Nobody's filed anything.
So Michelle, we're
given
going
notice.
for grid, and then we're going to make sure the case gets posted.
I'll
Okay.
hand
Put
it
that
over,
over.
Your Honor.
Okay, thank you so much. Have a great day.